I came home on a Tuesday to find an eviction notice taped to my front door. 7 years of on-time rent. 7 years of zero complaints. And they wanted me out in 30 days. That was the moment I decided I was done being a good tenant. I had moved into that apartment at 27, fresh out of a bad breakup and a cross-country move for a new job. The building wasn't fancy, but it worked for me. Second floor, 2 bedrooms, good light, walking distance to the train. My original landlord was a man named Gerald Hoffman. He had owned that building for over 3 decades. He was old school, barely said 10 words a month, but he was fair. Rent was reasonable. When something broke, he fixed it. When I renewed my lease for the 3rd time, he shook my hand and said, "Good tenants are hard to find." I actually felt proud of that. Everything changed when Gerald retired and sold the building to a property management company called Hargrove Residential. I found out through a letter slipped under my door one Friday evening. By Monday morning, I had a new contact number, a new portal to pay rent, and a new list of building rules that had not existed the week before. A mandatory building upkeep contribution of $60 was added to my monthly rent starting the following billing cycle. No explanation. No negotiation. Just a new charge. I called the number on the letter. A woman named Sandra answered and told me the fee was standard across all Hargrove properties and was outlined in the addendum they had mailed. I had never received an addendum. She said she would send another one. It arrived 3 weeks later, postmarked the same day I called her. I noticed that immediately but let it go. I was busy. I had a demanding job, a life to manage, and I genuinely did not want conflict. I paid the extra $60 every month for the next 4 years without ever saying a word about it. Looking back, that was a mistake. Not because of the money, though $60 a month adds up to nearly $3,000 over 4 years. It was a mistake because it taught Hargrove Residential that I was the kind of tenant who would absorb whatever they threw at me and keep quiet. And they kept testing that theory. In my 5th year in the building, they announced a renovation of the common areas. The lobby was getting new flooring, the stairwells were being repainted, and the laundry room was moving from the basement to the 2nd floor, directly across from my apartment. I raised a concern in writing that the construction noise and foot traffic would significantly impact my quality of life and asked whether there would be a rent reduction during the renovation period. The property manager at the time, a man named Brian Coulter, responded by email and said there would be no rent reduction but that they appreciated my patience. He also noted, in the same email, that they had reviewed my lease and found that my 2nd bedroom was listed as a home office in my original application, and that using it as a guest room could be considered a violation. I read that email 4 times. I had never told anyone at Hargrove how I used my 2nd bedroom. The only way they would know it had a guest bed in it was if someone had been inside my apartment without notifying me. I checked my lease. In my state, a landlord is required to give at least 24 hours written notice before entering a unit. I had received no such notice. I wrote back asking when and why my apartment had been accessed. Brian Coulter never responded to that email. I let it go again. I know how that sounds. But I was deep into a major project at work. My mother had just been diagnosed with a condition that required frequent trips back home, and I genuinely did not have the bandwidth to fight a property management company over an email. I filed it away in a folder on my laptop and moved on. The renovation finished 7 months later. The laundry room across from my apartment generated noise from 6 in the morning until 10 at night, 7 days a week. Nobody asked for my patience again. Then came the eviction notice. The morning I found it, I sat at my kitchen table with a cup of coffee and read it slowly and carefully 3 times. The stated reason was lease violations and failure to maintain unit standards. No specifics. No photographs. No incident dates. Just a blanket phrase vague enough to mean anything, which in legal terms usually means it means nothing. I called my friend Marcus that afternoon. Marcus is not a lawyer, but he has a law degree and works in corporate compliance, which means he knows how to read documents and how institutions use language to obscure intention. I read him the notice over the phone. He was quiet for a moment and then said, "They don't actually want you to fight this. They want you to leave." I asked him why. He said, "Because if they wanted to evict you for cause, they would have specifics. This is a pressure notice. They are betting you will just pack up." That was the moment something shifted in me. I had spent 5 years absorbing every new fee, every unanswered email, every minor violation of my rights as a tenant, because I did not want to be the difficult one. And now they were trying to remove me from my home with a piece of paper that did not even have the decency to tell me what I had done wrong. I was done being accommodating. I started with my own records. I had kept every email, every lease renewal, every written communication with both Gerald Hoffman and Hargrove Residential going back to the day I moved in. I printed everything and organized it chronologically. The unauthorized entry. The retroactive addendum. The unanswered email from Brian Coulter. The $60 fee that appeared without a signed amendment. I had more documentation than I realized. Then I started researching Hargrove Residential itself. They managed 11 buildings in the city. I found this through their own website. I began searching public housing court records, which in my state are accessible online. What I found was significant. Hargrove Residential had filed eviction proceedings against tenants in 7 of their 11 buildings within the past 2 years. Many of those cases had been dismissed or withdrawn. Some had resulted in settlements. A pattern was visible once you knew to look for it. They filed vague eviction notices, tenants panicked and left, and the units were relisted at significantly higher rents. I found 3 former tenants through online neighborhood forums who had received nearly identical notices to mine. One woman named Patricia had lived in a Hargrove building for 9 years and received an eviction notice citing unit maintenance concerns 6 weeks after she had submitted a formal complaint about a rodent problem in her building. She had left rather than fight. Her unit was re-rented 2 months later at $400 more per month than she had been paying. I contacted Patricia directly. She was still angry and agreed to share her documentation with me. I then contacted the other 2 former tenants. Both cooperated. Between the 4 of us, we had a substantial record of a company that appeared to be using vague eviction threats as a tool to displace long-term tenants and reset rents. I filed a complaint with the city's housing authority. I also contacted a tenant advocacy organization that connected me with a tenant rights attorney named Claire Osei who agreed to take my case. She reviewed everything I had compiled and told me, very plainly, that the eviction notice I had received had no legal standing as written. She sent a formal response to Hargrove Residential on my behalf within the week, citing the lack of specific violations, the documented unauthorized entry, the improperly added fee, and the pattern of similar filings across their portfolio. Hargrove's legal team responded by offering to drop the eviction in exchange for a signed agreement that I would vacate voluntarily within 90 days and waive any claims against the company. Claire told me to decline. I declined. The case went to housing court. Hargrove showed up with 2 attorneys. I showed up with Claire, 7 folders of documentation, and statements from Patricia and the other 2 former tenants. The judge reviewed the eviction notice and asked Hargrove's attorneys to specify which lease provisions I had violated and on what dates. They could not provide that information because it did not exist. The case was dismissed. After the dismissal, the city's housing authority opened a formal investigation into Hargrove Residential's eviction practices. Claire filed a separate civil complaint on behalf of myself and the 3 other tenants. That case settled out of court 8 months later. I cannot share the terms of the settlement, but I will say that I did not come out of it empty-handed, and neither did Patricia or the others. I still live in that apartment. The building changed management companies 18 months after the court case. The $60 monthly fee was quietly refunded to me as a correction to my account. My new property management contact is a woman named Teresa who responds to emails within 24 hours and once called me personally to let me know they would be doing routine inspections the following week and to ask if the scheduled time worked for me. It did. What I learned from all of this is not that landlords are evil or that tenants are helpless. What I learned is that people who want to take advantage of you are counting on the fact that most people, when pressured, will take the easier path. I took the easier path for 5 years. The eviction notice was the moment they overplayed their hand, and the only reason I was able to respond effectively was because I had, almost by accident, kept records of everything. Keep your records. Keep every email, every lease document, every written communication with anyone who has power over your housing. Not because you are planning to fight, but because you never know when someone is going to tape a yellow notice to your door and bet everything on the fact that you will not. They lost that bet.